The city's first witness, please. Do you solemnly swear or affirm under the penalty of perjury that your testimony in this trial to jury will be the truth?
I do. I am the prosecuting attorney. I am responsible for prosecuting all criminal cases in the city of Wheat Ridge. The role of the prosecutor is to seek justice, but essentially it's to represent the city in all criminal cases and either to have trials and to prove beyond a reasonable doubt that they are guilty, or where appropriate to make plea bargains and dispose of all cases with the idea of doing justice for the city of Wheat Ridge. As with the defense attorney, we each get to pick the jury pool paired down together. It starts out with 12 jurors, and then ultimately I will dismiss 3 jurors, and the defense attorney or the defendant will also dismiss 3 jurors. The only role I have with the jury is to ask them questions to determine if they, in my opinion, would make a good juror on the particular case in which I am trying. I can have no other contact with the jury outside of the process called voir dire, which means roughly to select a jury or to question the jury.
Jurors, please stand up and raise your right hands. Do you solemnly swear or affirm under penalty of law that you and each of you will well and truly try the matter at issue between the people of the city of Wheat Ridge and the defendant and render a true verdict according to the evidence? Yes. Please be seated. The way a criminal jury trial starts is that I introduce the case to the jurors. Then each party may give what's called an opening statement. It's not evidence, but it's what they believe that the evidence in the case will be. The prosecutor then calls a witness. They have to go first. It's their burden to prove beyond a reasonable doubt the guilt of the defendant. After the prosecutor completes their presentation of evidence, the defendant has the option, but is not required to then put on evidence. If the defendant puts on evidence, then the city can come back and put on additional evidence to clarify or to rebut the evidence that the defendant put on. After the evidentiary portion of the trial is finished, each party may then make what's called a closing argument. They wrap up the evidence for the jury. Typically, the prosecutor requests a guilty verdict and the defendant requests a not guilty verdict. The jurors are instructed at the beginning of the trial to not form an opinion, to not talk about the case amongst themselves until we've finished with opening statements, the testimony and evidence, closing arguments. Then they may go back into the jury deliberation room and discuss the facts as they decide them to be in the case. The facts in the case can only be discerned from testimony in the courtroom. They can't use outside knowledge. They should not be visiting the scene of the crime. They should not be making phone calls and talking to people. What they know about the case, they have to learn here in the courtroom. So what they do is take the facts as they decide them to be, apply them to the law that the judge will give them during the trial and at the end of the trial, and then they deliberate and discuss the case. Their verdict has to be unanimous, that is, all the jurors have to agree to it. They then have to actually sign, each juror signs a verdict form. They come back into court, and then the judge reads that verdict to the defendant. Mr. Dunlap, please stand up and I'll read the verdict to you. We, the jury, find the defendant not guilty of illegal sales and solicitation. So please be seated, Mr. Dunlap. 2 to 3 years ago, the Supreme Court of the state said that they would like jurors to become more involved in the jury process. So the Supreme Court issued some rules that said that jurors can, 1, take notes, and 2, they can ask questions. Those questions are in writing. The judge can reject the question, just like a judge can reject a question from a party in a case. And if the question is appropriate, the judge will ask the witness that question, and the question becomes a permanent part of the record.
Citizens requested to be on a jury panel is very important for them to appear, because without their presence, we would not be able to hold a jury trial, and the defendant would not be allowed to be judged by a panel of their peers.
I enjoy being a judge for 2 or 3 different reasons. 1, the job can be mentally challenging. 2, we do have some interesting cases that appear in municipal court. 3, hopefully the court is deterring crime, it's providing public safety, It is rehabilitating persons. Participation in the jury process by citizens is critical. It's a system that was devised to prevent the government from becoming oppressive. And if you have citizens coming in and determining whether or not somebody is guilty or not guilty, it lends some credibility and some legitimacy to the criminal justice process.